Welcome friends. Today we are going to discuss about an important topic in the Constitution of India, that is citizenship. This topic assumes more importance in the context of Citizenship Amendment Act 2019 CAA. But before we go into that, I strongly believe that I should provide certain explanation to various terminologies used in the Constitution, because that terminologies are neither explained or not defined in the Constitution of India. For example, the term national, nationality, domicile, residence, citizenship, etc. Let us come back to nationality or nationals. Nationality and citizenship generally goes hand in hand, but not necessarily always. And it's not one and the same. A person can be a different national having different citizenship. Say example, an Indian national can acquire a citizenship in US and he may reside in US, but in case any problem happens to that person, sometimes US may declare him as an alien enemy, persona non grata. So what happens to that person? Who can take up his case before the ICJ, or for that matter any other international forum? Only India can take up his case. So this has happened typically in a case called Gautamala versus Liechtenstein, popularly known as Dr. Natebaum case. If you study international law, you may get more detailed account about all these things. Then there is one more convention which regulates the grant of nationality is concerned. Particularly for the women, they are given double nationality because they may marry in some other country. They are giving birth in one country, but they generally, because of marriage, they may go to some other country. So by virtue of this status, they are acquiring double nationality, but they can choose either of the nationality after certain times. This has been prescribed and regulated through an international convention. Unfortunately, I don't remember the name of the convention for the time being. However, we may ask our students to provide you in the PPT. Okay, this is very important. So next is known as domicile. What is a domicile? How can you conclude whether a particular person is a domicile or not? How will you determine? There are two tests. Two tests must be applied cumulatively, not disjunctively. This is very important. You should fulfill both the conditions. It is and, not or. This is very important. First, he should reside in a particular country permanently, habitually, intentionally, and physically. Animo permanent, animo e factum and possidendis. Both must be available. He should not reside in a country for any particular purposes like job, employment purposes, economic purposes, business purposes, or any other purposes. He should reside the country in a particular country habitually, voluntarily, and intentionally, and it should be made available physically in that particular country for a quite long prescribed time, which may vary from country to country. Next comes citizenship and residence. Residence is also one of the important conditions acquiring citizenship in many of the jurisdictions. The residential status, again, it has not been defined in the Constitution of India, but has been better explained, or the best explained, in the Income Tax Act. Please refer section 5 and 6, which gives you a detailed account about residential status such as resident, non-resident, resident but not ordinarily resident, and ordinary resident. All these terminologies have been explained in the Income Tax Act 1961, at least in the Indian context. Please, you should remember, citizenship is purely prerogative of the sovereign country. There is no international law which regulates citizenship. Whereas nationality, yes, it is regulated by international law to a greater extent, including there is an article in UDHR which talks about every person should have a right to nationality. But it cannot mandate every person should have a right to citizenship. So you can understand the difference between nationality and citizenship by this point of time. Now let us go back to Constitution of India. Part 2, Article 5 to 11 speaks about citizenship. Article 5 speaks about how to acquire citizenship at the time of commencement of the Constitution. Because suddenly the Constitution comes into picture. So you cannot say these persons are citizens, these persons are not citizens immediately. So therefore certain arrangements must be made available. The Constitution makes interim or transitional arrangements subject to the approval of the Parliament under Article 10 and subject to the regulation of law made by the Parliament under Article 11 of the Constitution. This is very important. So 5 stipulates few conditions. First, the person should be a domicile in this country. Next, he should have been born in this country or his parents have born in this country. Either of the parents have born in this country. And you should be resident at least for a period of 5 years prior to the commencement of the Constitution. This is very important. And then we go to Article 6 and 7. 6 and 7 is known as confusion. But please don't get confused because it is quite related with one another. Article 6 speaks about the rights of the migrants from Pakistan to India, whereas Article 7 speaks about rights of migrants from India to Pakistan. If you say just otherwise, you may lose the marks. Article 6 talks about the rights of the persons who have migrated from India to Article 6 talks about the rights of the persons who have migrated from Pakistan to India. There is a cutoff date. What is the cutoff date? 19th July 1948 is the cutoff date. If any person who has migrated from Pakistan to India on or before 19th July 1948, he is simply deemed a citizen of this country. In case if he migrates after the cutoff date, that is 19th July 1948, then he needs to follow certain extra procedure. That is, he himself has to register himself as a citizen under this country in the prescribed manner, in the prescribed format, prescribed by the competent authority, which was in force for the time being at that point of time. So that's very important. And he should have at least 6 months should be there before he files an application. This condition is equally applicable to the persons under Article 7 also. Let us go to Article 7, which speaks about persons who have migrated from India to Pakistan. Simply they lose their citizenship. They are deemed that they are not citizens. The persons who have migrated from India to Pakistan by 1st March 1947, they lose their citizenship. In case if he has any dilemma, he thinks over after some time and he comes back to India through a permanent settlement or through a permit issued for this purpose. In that case, he will be deemed that he has migrated by 19th July 1948. Accordingly, he should follow certain procedures, additional procedures such as registration and all other things. Then we go to Article 8, which speaks about rights of persons of Indian origin who are residing outside the territories of India, how they can acquire the citizenship. Any person who is residing outside the territories of India, he himself may be born in this territory or his parents, either of his parents or either of his grandparents could have born in this country. And in that case, he should approach the Indian embassy where he resides, in a particular country where he resides, and submit the prescribed application format in the prescribed manner, prescribed by the competent authority, and by registration he can acquire the citizenship in India. Next comes Article 9, which talks about renunciation of the citizenship. Any person who voluntarily acquires the foreign citizenship is deemed to be not the citizen of this country. His citizenship get automatically terminated by default, or you may call it de jure termination of this citizenship. Article 10 speaks about that whatever arrangements made under Article 5, 6, 7, 8, all these things are temporary in nature or transitional in nature. It can be varied, modified, approved, confirmed, cancelled, nullified by an appropriate law made by the Parliament. Parliament has all the competencies. So, though I would have got my citizenship at the commencement of the Constitution by virtue of Article 5, but my citizenship is subject to the approval of the law made by the Parliament relating to that subject matter in the future. Then Article 11, which gives complete power to the Parliament of India in the matters connecting acquisition, termination, and all other matters connected to the citizenship. Now one should remember, under Article 12, the Supreme Court has adopted two different interpretational principles. In certain set of cases like Umanath versus State of UP, the Supreme Court said the term other authority cannot be given wider interpretation because one needs to follow the Justem Generis principle. Whereas the same Supreme Court of India has reversed the same, and they said Justem Generis principle will not be applicable under Article 12, particularly for the term other authorities. So in this case, we do not know. Why I am talking about, if the Supreme Court feels applies the Justem Generis principle, then the constitutionality of the constitutionality of 2019 amendment is it has a decisive role on the determinants of the constitutionality or constitutional validity of the 2019 amendment. Let us see what the Supreme Court is going to adopt and whether it is going to approve the constitutionality or it is going to declare void ab initio. These aspects we will discuss it in a separate lecture. Before I conclude, I would like to thank some of our friends like Divyadashni, Kirtana and Sushmita. As usual, our administrator Gokul Raj, who happens to be the host of this channel. Thank you all. If you have any comments, please post your comments in the comment section. We would like to answer you. If you are not subscribed the channel, please do the same so that it will motivate the persons who are associated with the channel. God bless you all. Thank you.